Good afternoon. Paul Fox is here with myself, Tom Bailey. We are two ethics trainers. We have an Act 48 course and a PIL course. And today we'd like to talk about what's going on with William Penn School District versus PDE. Now, last week on May 22nd, there were oral arguments in front of Judge Jubelirer. So we want to talk about, as far as a William Penn update, that's about where we are, what's happened so far, and that's what we're going to discuss today. We're going to look at the William Penn opinion. We're going to look at specifically Judge Jubileer's text in the opinion. Then we're going to look briefly at the procedural history. And then I'm going to summarize the post-trial arguments by counsel that was on May 22nd. So I would like everybody to be able to look at this opinion and review it easily. And I'd like to do that by sharing my screen and taking you to the Commonwealth Court opinion. So I would just type in any search engine, Pennsylvania Commonwealth Court. And when you do that, this is likely going to come up Commonwealth Court and a unified judicial system. If you click on that to go to Commonwealth Court, that'll get you started to actually see the opinion. So here we are in the Commonwealth Court website homepage. Now, when I ended my practice of law before becoming a teacher, this picture would have been the exact opposite, and that was in 1991. So I think there may have been one or two women and the rest were men. But in 2023, there's one man on the Commonwealth Court and the rest are women, with the woman in the front middle being President Judge Jubelirer, who wrote this opinion. So if you want to see the actual opinion, scan down just below the picture and look for cases of public interest. And they list several cases that they get the most questions on. And so we're going to click on cases of public interest here. Now, they do the cases of public interest for both the Pennsylvania Supreme Court, which they list first, and they also list the Pennsylvania Superior Court. We'll continue down to the Commonwealth Court, and you'll see William Penn School District. Et al. Just means there's other parties versus Pennsylvania Department of Education and other parties, and click on that link. And that will bring you to this page, which are the most recent filings of court orders in this court case. Specifically, we're going to be looking at the February 7th, 2023 memorandum order. Now, after that order, the parties are able to file joint applications for relief to the trial court, so they can go over any issues to perhaps avoid an appeal. And then on February 28th, she scheduled this oral argument for May 22nd. So briefly, let's look at the actual court opinion from February 7th. This is what we call a caption. And the caption, you can see the actual parties that were the plaintiffs or petitioners here. 6 school districts all across the state. 3 groups of parents with their children. The Association of Rural and Small Schools, and also the National Association for the Advancement of Colored People, the Pennsylvania State Conference. And in 2014, they filed this lawsuit against, sorry about that. These are the respondents coming up here. The respondents in 2014 was the Senate pro tempore, who has now left the Senate, has been replaced by Kim Ward. Mark Rossi in February was the Speaker of the House. He has now been replaced by Joanna McClinton. Josh Shapiro is now the governor. They also sued the Pennsylvania State Board of Education and the Pennsylvania Department of Secretary's acting secretary, who has now been replaced. So over the 9 years, there's been a lot of change in the respondents. So if you continue down past the caption page, you come to the table of contents, and I'd just like you to see the detail that Judge Jubelirer, in my opinion, provided as a basis for her decision. The court case goes on, the opinion goes on for 798 pages. I would like to show you one specific part. Each of the school districts that filed suit, she took the time to review their specific instances based upon the testimony she heard. I'm going to show you one of those. And again, to show you the detail that the court went into. There are several others, but let's look at the Lancaster School District. And as I go through here, please look at the amount of detail that the judge provided. Everything from the ages, and there are two charts for each school district. This one specifies the demographics on 3 different school years. And on the left-hand side, if you can't see this very well, it is blurred. Total students, then it's divided by race, special education percent. I'm not aware what ELL is, then economically disadvantaged, the ranking in the state, homeless population, foster care. And in a second chart, to give details based upon PDE figures. As far as the weighting, the median household income, market values, again, to try to give a rationale for the judge's decision. Amount of teachers, the amount that teachers are paid, the other academies and career and technical centers that are involved with the schools are also included in this, in the opinion, to flesh out what the judge saw of these 6 school districts. I believe in most of the school districts, the superintendents testified, and so this summarizes their testimony. There's a few pictures we're going to come up to here from the Lancaster School District to try to verify their allegations about their physical plant. Cyber pathway charter schools, career technical centers, the effect of COVID, role of technology in the schools, bringing the students back after COVID, independent reading programs, curriculum, specifically at the high school, internship programs, dual enrollment programs. AP exams, independent study, very detailed. And again, there are 6 total different school districts that went through this level of detail.
Call from call Judy.
All right, I appreciate your patience. Because there's so many pages in this, it's not very easy to go from one section of the opinion to the other. I believe we're coming up to, I think there's 4 or 5 photographs here that are representative of what other school districts also displayed. Okay.
Here they come. Yep.
And I'm reading now from the opinion. The school also had deteriorating classrooms, and due to lack of space and inadequate classroom space for small groups, it forced teachers and support staff to create spaces and hallways, like the one picture below, to provide interventions. Lack of space also forced teachers at Wickersham to create student study spaces in the basement. Similarly, at Carter and McRae and Hamilton elementary schools, space had to be converted in an area for instruction. Last one.
Oh my.
And so where there's water dripping from the ceiling, they had to adapt by putting a trash can to catch it. And were apparently unable to repair it.
This is just one of the 6 districts that was having low quality facility.
Yeah. Okay. Let's go to Judge Jubileer's opinion. Two pages. The Education Clause, Article 3, Section 14 of the Pennsylvania Constitution requires that every student receive a meaningful opportunity to succeed academically, socially, and civically, which requires that all students have access to a comprehensive, effective, and contemporary system of public education. Respondents, which you have seen there, have not fulfilled their obligation to all children under the Education Clause in violation of the rights of petitioners. Education is a fundamental right guaranteed by the Pennsylvania Constitution to all school-age children residing in the Commonwealth. I can tell you right now, that's a precedent-setting part of her opinion that had not been decided in prior law within the state of Pennsylvania. Article 3, Section 32 of the Pennsylvania Constitution imposes upon respondents an obligation to provide a system of public education that does not discriminate against students based on the level of income and value of taxable property in their school districts. Students who reside in school districts with low property values and incomes are deprived of the same opportunities and resources as students who reside in school districts with high property value and incomes. The disparity among school districts with high property values and incomes and school districts with low property values and incomes is not justified by any compelling government interest, nor is it rationally related to any legitimate government objective. As a result of these disparities, petitioners and students attending low wealth districts are being deprived of equal protection of the law.
Wow.
Okay. So procedurally, what happened in this case? The case was filed in 2014. Immediately, the respondents filed a motion to dismiss the case. They claimed that it should be dismissed because the petitioners had not joined all the necessary parties to be plaintiffs, and they thought that there'd be many, many, if not all of the school districts. And they felt that the not just the Speaker of the House and the President pro temp of the Senate should be joined, all of the House and the Senate should be made parties to this lawsuit. So they argued to the Commonwealth Court the case should be dismissed. They also said that it was a political question, one that cannot be decided by judges, but should be decided by the legislature. And the Commonwealth Court agreed and dismissed the entire lawsuit. The petitioners then appealed to the Pennsylvania Supreme Court, and the Pennsylvania Supreme Court reversed and remanded this case and told the Commonwealth Court, you now have to dispose of any other preliminary objections. And that Pennsylvania Supreme Court case is known as William Penn 2, and that was in 2015. So the case came back to Commonwealth Court. They denied any of the other respondents' remaining preliminary objections, and in 2018, they were ready to proceed. Now, thereafter, the General Assembly changed its funding formula. They changed the way that they were allocating money to go to the state. And the Commonwealth Court looked at the petitioners and said, well, do you want to amend your complaint based upon this new statutory funding? And the petitioners said they did not. So in 2020, pretrial discovery and went on, which is where the sides showed evidence to each other as to what they were going to present at trial. And there were several extensions granted. The opening trial statements was in November of 2021, and the trial went on for 49 days through the winter of 2021 and 2022. The closing arguments were presented to Judge Jubelirer in the summer of 2022, and she then began writing the opinion, which was published February of this year. Now, the attorneys for all of the respondents could file post-trial motions objecting to it. Two of the attorneys did. One attorney was Patrick Northern. He's with the law firm of Dilworth and Paxton, and he represents Representative Cutler. And again, these are post-trial. They're trying to let the judge make revisions to her opinion, so there may not need to be an appeal. And the first thing he said was that in New Jersey in 1973, an equity school funding case was filed. And he said, and that school funding case is still going. He said, that's the same thing's going to happen here in Pennsylvania. The funding cases are going to be endless in litigation unless the judge would take steps to stop it by revising her opinion. And he also said that New Jersey still has an extensive achievement gap between high wealth districts and low wealth districts. He went on to say that the court should have allowed the petitioners to add what he called indispensable parties, other school districts and career technical centers whose interests were interlocked with the 6 school districts, because this would allow a statutory, if they altered the funding mechanism, those schools would have had something to say about it. But the court did not allow them to enter, and Attorney Northern said that was an error. He also said that the plaintiff should have named the entire House of Representatives and Senate for Pennsylvania, not just the leaders. Mr. Northern said that the students had now graduated from high school, and so therefore it was a moot point. There really was nothing to argue about because the young people that were named in the original suit in 2014 were no longer in high school. And he said that the court erred in refusing to adopt the General Assembly's interpretation of what the education clause is in the Pennsylvania Constitution. And he said it should be this, that they must establish and maintain and support a system of public education that provides K through 12 students with an, quote, opportunity to obtain a basic standard public school education, end quote. And that is what they have been doing. and that he feels that is what is appropriate. He had went on to say that the General Assembly may consider and give legitimate governmental objectives to making efficient use of taxpayer funds on other items other than public education, and that the judge didn't consider that appropriately. And he went on to say that the education clause says that the quote is that the legislature is to serve the needs of the Commonwealth, end quote. But it does not say that the legislature is responsible to produce students who, as adults, can participate in society academically and civically, which serves the needs of the Commonwealth. And that's what Judge Jubelirer had said was necessary. Attorney Northern also stressed the importance of local control. He said the local school boards are not going to know how they're supposed to spend the state money. And shouldn't they be able to spend the state money any way they saw fit? And by going in and changing the amount of state money, the court was restricting their amount of local control. He also went on to say that he's a realist and he believes in the preservation of the status quo. And he said that Leader Cutler is serious in that this decision is going to lead to endless litigation about this topic. He said that the plaintiffs failed to show that within the system of public education, there was a substantial number of school districts, not just 6, that are unable to provide adequate education. And that the focus on educational opportunities is the way to go. That is the availability of an education, not the actual provision of it. And that there's no way to measure Judge Jubelerer's, in quotes, socially and civically successful education. It can't be done. And in closing, he said that looking at the basic standard situation that they've been using, currently 88% of the students in the public schools pass, and that met the basic standard provision. He sat down. Attorney Tom DeCesar was the attorney for Senate Leader Kim Ward, and these are his arguments. He said that the court erred in ruling on several civil procedure issues. One specific example he gave was the petitioners had a witness named Dr. Kelly, and he said that Dr. Kelly admitted that he was not an expert on PVOS, a Pennsylvania Department of Education program, but yet the judge let him testify to it. He said that's an error on her behalf. Secondly, he said that students don't have a fundamental right to a certain quality of education. They have a right to the opportunity to receive that education. He continued on to say that at the end of the trial, none of the petitioners had actually remained as students, similar to what Attorney Northern had said. And therefore, all the issues are moot, and the legal effect of this opinion is advisory, not binding on the Senate and House Representatives. He continued on to say that meaningful academic, civic, and social success can't be quantified. And as a result, success to be measured by individual students is not going to be possible. He went on to say that school staffing, the number of kids, class sizes, those are not something for a judge to decide. Those are political decisions to be made by the legislature and the legislature alone. He said that the court had erred by not assigning enough weight to the education outputs of PVOS, standardized test scores, and Keystone scores. And that the court had only looked at really 491 out of the 499 school districts in the state. She only looked at 2% of the entire Pennsylvania public school system. Didn't refer at all to the career and technical centers, didn't look at the public libraries, and didn't look at the intermediate units. And as a result, her decision was flawed. Now, at this point, Judge Jubelirer interrupted him, which happens sometimes during oral argument. And she said, well, who is responsible to interpret the text of the Pennsylvania Constitution? And Attorney DeCesar said, well, it should be interpreted by the legislature, because the legislature is the one responsible to fit legislation to empower and carry out what's in the Pennsylvania state constitution. her response was, well, in her opinion, it was the role of the judiciary to interpret whether or not the legislature's interpretation of the Pennsylvania Constitution was appropriate, and that's one of their roles, is to act for judicial review. Attorney DeCesar sat down. At this point, one attorney came forward and said that he was speaking for the executive respondents, which would include the current governor, the current Secretary of Education, and the current State Board of Education. He said the opinion was well-reasoned and there was no error of judgment in his opinion. And then the last attorney to speak represented House Speaker Joanna McClinton. And this attorney said that the opinion was comprehensive and requested that the judge did not change the opinion. The last attorney to speak was the attorney that spoke for petitioners, represented by the Public Law Interest Center and the Education Law Center. And it was attorney Dan Urivik Acklesberg. And this attorney said that Judge Jubelirer had done exactly what the Pennsylvania Supreme Court had directed the Commonwealth Court to do in the William Penn II decision. And that was the extent of the oral argument by the parties. What questions, if any, do you folks have? If you have any that you'd like to go over, we'll do that.
One question I have is, where are we at this right now? What's the next step? Do you know?
Yes, what's happening now is there's a timeline. The clock is ticking. And the respondents, because they're the only ones that raised an issue at post-trial, respondents have so many days now to decide if they're going to appeal Judge Jubelerer's opinion to the Pennsylvania Supreme Court.
So it could go back up to the Supreme Court again.
It could go back up to the Supreme Court. I will say at one point, one of the two attorneys, I forget who it was, said that he understood that it was going to be a formidable task to take it to the Pennsylvania Supreme Court to overrule Judge Jubelirer, because as you heard, the plaintiff's attorneys, petitioners, said you did exactly what they asked you to do. And so I don't know that there's going to be an appeal, but that's the next item. And everyone should know that there's, from my understanding, there's no possibility of an appeal to the U.S. Supreme Court, because this case is so largely based upon the Pennsylvania Constitution. Now, they could try something. They could try to make an argument that the fundamental right that they're claiming, there's a violation, but I don't expect there to be any possible appeal to the U.S. Supreme Court, but there definitely could be an appeal to the Pennsylvania Supreme Court.
I was just sitting here listening to all this and going, if this judge's decision prevails, what will happen? I mean, if it doesn't go up, or if it goes up to the Supreme Court and they hold her position as it is, what will happen? I mean, we're talking about the basis of funding in the state of Pennsylvania. I had looked it up, and it's about 47% comes from the state government, and about 45% come from local government resources, of which 36% come from property taxes. It's only a tiny amount, 8%, that comes from federal government. So, you know, if indeed we are not providing in this state equitable education, funding of education, I guess the judge throws it back to the legislature and say, now fix this. And that's what this is all about. And then, you know, that is a massive, I mean, in other words, the state would have to pick up the difference of the Lancaster districts that have desks in the center of the hallways or leaking ceilings, some of the facility issues, and you know, I taught in a public school that was an upper middle class. We had things. They complained they didn't have enough funding for education. I just don't know what the future would hold if this judge's decision prevails.
Well, I've seen some criticism of Judge Jubelerer's, because you folks, we read it. It's only 8 paragraphs long, the actual order.
Mm-hmm.
And so she is largely, from her at this point, leaving it up to the legislature to fill in all the details. You didn't see any percentages there. You didn't see any amounts, years that had to be done to qualify. and to satisfy her opinion. So it's wide open, but it would be subject to, let's say they take action and some other members of the legislature or other members of the public feel there's a violation. They could come back into Commonwealth Court and say, we feel that the existing system is not meeting the specifics of your order. But there are not many milestones there as to how that's to be done. So I'm not sure the details in carrying it out.
After all the years, I don't remember a court case like this. And certainly over the years that I went to school in Pennsylvania, the issue going up to the Supreme Court, back down to Commonwealth. Well, Commonwealth wasn't always there. This is a remarkable moment, and we have to follow this from that timeline you were saying. We have to see what goes on next.
Yes. Yeah, I'll keep you updated when another procedural action happens.
So just to tell everybody who might be reading in on this email, a week from today, we are going to approach a couple more of these different topics and ethics in education and issues in education, just Q&A, and anybody wants to join us. This will be up on the Thomas Bailey, TW Bailey Law at twbaileylaw.com website. And I'm going to do Model Code of Ethics for Educators in a week. And we're going to look at the new Code of Conduct. And we're going to look at Education Discipline Act. We're going to look at the Pennsylvania Commission. So we've got some more of these kinds of seminars. Come and join us. If you are watching this as a video, just go to TW Bailey. Is that right? TW Bailey .com or law, twbaileylaw.com, and see what's coming up.
Thank you.